The letter arrived on a Tuesday. Not a phone call, not a conversation, not even a knock on the door from someone brave enough to look me in the eye. A letter. Certified mail, signature required, delivered by a postal worker who handed it over with the mild indifference of someone who has no idea they're carrying a grenade. I signed for it, went inside, set my coffee down on the kitchen counter, opened the envelope, and read the words that my own family had filed a petition with the county court to have me declared legally incompetent. I stood there for a long time. The coffee went cold. The clock on the microwave kept blinking because I'd never reset it after the last power outage, and I remember thinking how strange it was that I was focused on that stupid blinking clock, when the floor had just dropped out of my entire life. Incompetent. The legal word for it is incapacitation. It means a judge decides you can no longer manage your own affairs. It means someone else gets to control your money, your property, your medical decisions, your future. It means you become, in the eyes of the law, a ward. And the people who filed the petition, the people who had checked the box on that court document stating they believed I lacked the capacity to make sound decisions? My sister Renata, my brother-in-law Dale, and my mother Eleanor, whose signature sat at the bottom of the page in the careful, deliberate cursive she used when she wanted something to look official. I read the document 4 times. Then I folded it, put it back in the envelope, and walked to my home office. I sat down at my desk, I opened my laptop, and I did the one thing that would change everything. I called Marcus. Marcus Thyde had been a licensed private investigator for 19 years. I'd been referred to him 2 years earlier by my attorney, not for anything dramatic, just a background check on a contractor who'd given me an estimate that felt too good to be true. The contractor turned out to be exactly as dishonest as my instincts suggested. Marcus found 3 outstanding civil judgments against him in 2 different states inside of 48 hours. After that, I kept his number. When I called him that Tuesday afternoon, I didn't tell him everything right away. I told him I needed comprehensive financial surveillance on 3 individuals, a full asset search, a review of any legal filings bearing my name, and documentation of any communications or actions that might suggest coordinated intent. Marcus was quiet for a moment. Then he said, "Tell me what happened." So I did. He was quiet again. Then he said, "When did this start?" And that was the question, wasn't it? Because the letter was Tuesday. But the answer to when this started was something else entirely. Something that went back not weeks, not months, but years. Decades, maybe, depending on where you draw the line between a family that underestimates you and a family that decides to profit from it. I need to tell you about who I was in this family, not who I became. Who I was. I was the quiet one, the one who read too much and talked too little, the one who, at family dinners, could be found in the kitchen helping whoever was cooking rather than in the living room where the real conversations happened. My mother called it being shy. Renata called it being weird. Dale, who came into the family when he married Renata 18 years ago, called it being slow, though usually only when he thought I couldn't hear him. I have a processing disorder. It was diagnosed when I was 9 years old. It means that in certain environments, particularly loud, chaotic, socially demanding ones, my brain takes longer to sort incoming information. I sometimes repeat words while I'm thinking. I sometimes lose the thread of a conversation and have to ask for things to be repeated. In school, it meant I needed extra time on tests and a quieter room for exams. In life, it meant people made assumptions. My mother, to her credit, never called me incompetent, but she also never corrected anyone who implied it. There's a particular kind of harm that lives in that silence, the harm of a parent who loves you, but also wants the peace that comes from not making waves, not challenging the narrative, not saying the uncomfortable thing. My mother loved me and she let people diminish me, and somehow in her mind, those 2 things coexisted without contradiction. By the time I was in my 30s, I had learned to live inside the version of me that my family had decided existed. Not because I believed it, but because fighting it at every dinner table, every holiday, every phone call was exhausting. So I smiled. I helped in the kitchen. I listened more than I spoke. And I worked. God, I worked. What my family did not know, because I had stopped volunteering information to people who used it to diminish me, was what I had built in the years since I left the job I'd held for a decade at a regional insurance firm. I left that job in 2017. I had been a senior claims analyst. I was good at it, exceptionally good, because the same brain that struggled to track 5 simultaneous conversations at a loud dinner table was extraordinary at finding patterns in data, at spotting inconsistencies in documentation, at holding complex logical structures in mind, and rotating them until the error became visible. I left because I had a plan. For 3 years before I left, I had been developing software, not casually, methodically. I had identified a specific gap in how mid-sized property insurance companies handled subrogation recovery, the process by which an insurer recoups payments from the party responsible for a loss. It was an area drowning in manual processes, missed deadlines, and lost revenue. I had built a system that automated the workflow, flagged time-sensitive recovery windows, integrated with court filing databases in 42 states, and generated compliance documentation automatically. I tested it quietly using anonymized data sets. I refined it for 2.5 years. I filed a provisional patent application in 2016, a full utility patent application in 2017, and by the time I walked out of my last day at the insurance firm, I had a signed letter of intent from a regional carrier in Ohio who wanted to pilot the system. The patent was granted in 2019. United States Patent Number 10-489-774. I can tell you that number from memory because I have looked at it many times, on days when I needed to remind myself of what was real. By 2021, I had licensing agreements with 7 carriers. By 2023, 11. The system was handling recovery workflows for over 400 claims offices across the country. I had a small team, 3 full-time employees and 2 contractors, all of whom worked remotely, and all of whom I'd never once mentioned to my family. I had also in 2020 purchased the house I lived in outright. No mortgage. Cash transaction. My family knew I owned the house. They assumed I'd gotten a good deal and stretched a loan. The idea that I might have simply bought it never seemed to occur to them. I'm telling you this not to boast. I am telling you this because the people who filed that petition with the court had decided I was incapable of managing my own affairs. I want you to understand exactly how wrong they were, and exactly how extensively I could prove it. Marcus called me back 3 days after our initial conversation. He had preliminary findings. I listened for 40 minutes, taking notes on a yellow legal pad in the shorthand I'd developed over years of sitting in meetings where I needed to capture information without anyone seeing how carefully I was paying attention. What Marcus had found was not subtle. It started, as these things often do, with money that had gone missing. Specifically, money from my father's estate. My father, Gerald, had died in 2019 after a short illness. He was 68 years old. He had worked his entire adult life as a civil engineer, had been careful with money, had owned property. His estate was not enormous, but it was substantial. The house he and my mother had lived in for 30 years, a small commercial property he'd purchased in 1998, a brokerage account, and a life insurance policy. The will, which I had seen briefly and which my mother's attorney had summarized in a letter sent to me and Renata, divided everything equally between the 2 of us, with a life estate for my mother in the family home. That had always seemed right to me. It had also seemed like something I didn't need to scrutinize too closely, because what kind of person scrutinizes their father's estate distribution while they're still grieving? The kind of person who should have. Because what Marcus found working with a forensic accountant he brought in on the case was that the commercial property had been sold in 2020, 14 months after my father's death, for $412,000. And the proceeds had been deposited into an account in my mother's name and then transferred in 3 installments to an LLC registered in Delaware. The LLC was called GDR Holdings. The registered agent was Dale Raymond, my brother-in-law. I need to stop here and tell you what I felt when Marcus walked me through this, because I think the feeling matters. I did not feel the sharp, hot surprise of a person who had no idea. I felt something colder and quieter, the specific sensation of a suspicion you've carried for years being confirmed, not with a dramatic reveal, but with paperwork, with account numbers, with transfer records, with a Delaware corporation that had been registered 11 months before my father died. 11 months before, which meant someone had planned this before he was even gone. I sat in my home office with Marcus's preliminary report on my screen, and I felt something crystallize in me. Not rage, not grief, a specific, clear-headed resolve. The kind that doesn't shake, the kind that makes you very, very careful about what you do next. I told Marcus I needed everything, every transfer, every document, every filing, every communication he could legally access or compel. I told him I needed to understand the full scope before I took a single visible step, because I knew that once my family understood that I was aware, they would move quickly. Marcus said, "Understood." And then he said something that has stayed with me. The best thing about people who underestimate their target is that they get sloppy. They stop being careful because they don't think they need to be. He was right. They had been very, very sloppy. Over the next 6 weeks, Marcus and the forensic accountant, a woman named Dr. Patricia Holloway, who had testified as an expert witness in over 60 civil cases, assembled a picture that was comprehensive, documented, and damning. The commercial property sale proceeds. $412,000 moved through GDR Holdings, used to purchase 2 residential investment properties, both titled in GDR Holdings' name, both generating rental income that was flowing to Dale and Renata. My share, 0, not delayed, not in dispute, simply never mentioned. The brokerage account, my father's portfolio, which had been valued at approximately $280,000 at the time of his death, had been transferred in its entirety to an account in my mother's name within 60 days of probate closing. My mother had then, over the following 18 months, liquidated the positions and transferred the funds in a series of transactions, none of which exceeded the federal reporting threshold, to 2 destinations: a personal account in Renata's name and GDR Holdings. Again, my share, 0, the life insurance policy. This one was cleaner because it predated the manipulation. The policy had listed me and Renata as equal beneficiaries, and I had received my half $60,000 without issue. This appeared to be because the life insurance policy was not subject to probate, and therefore harder to redirect without my direct signature. They had taken what they could take without my signature, and what they couldn't take without my involvement, they had left alone. The total amount redirected from my father's estate, money that should have been divided equally between me and my sister, was conservatively estimated by Dr. Holloway at $346,000. And then there was the competency petition. Marcus had obtained, through a records request, the supporting documentation that Renata and Dale had filed with the court. It included a letter from a physician. The letter stated that I had exhibited concerning behavior consistent with cognitive decline, specifically mentioning a conversation at a family gathering in which I had become confused and repeated myself. I read that letter 3 times. The physician who signed it was a geriatric specialist who had no record of ever treating me, examining me, or having any clinical contact with me whatsoever. His license was current. His credentials were real. But his signature on a letter describing my cognitive state was, according to every legal standard that existed, fraudulent. Someone had either forged his signature or, and this possibility made my blood run cold, paid him to sign something he shouldn't have signed. Marcus was already on it. He had sent a formal inquiry to the physician's office. He was also in contact with an attorney who specialized in elder law and estate fraud. That attorney's name was Christine Weller. Christine Weller was 61 years old, had argued cases in front of 3 state Supreme Courts, and had a reputation in the legal community that I can only describe as surgical. She did not do dramatic. She did not do passionate courtroom speeches. She built cases the way engineers build bridges, load-bearing, precisely calculated, and designed to hold weight that would collapse anything less rigorously constructed. I met her in her office on a Thursday morning. I brought Marcus's preliminary report, my own financial records, my patent documentation, my business registration papers, my corporate tax returns for the past 4 years, my personal tax returns for the past 7, and a detailed timeline I had constructed over 2 evenings that mapped every event I could document against the financial movements Dr. Holloway had identified. Christine reviewed everything for 4 hours. She asked precise questions. She made notes. She asked me to walk her through my processing disorder diagnosis, my current cognitive function, and the specific allegations in the competency petition. She did this without condescension, without softening, without the particular careful tone that people sometimes use when they're not sure how much you understand. At the end of the 4 hours, she put down her pen and said, "There are 3 separate legal actions here, and they need to proceed in a specific sequence. First, a formal response to the competency petition, including a motion to dismiss and a counter affidavit supported by documentation of my professional and financial functioning. Second, a civil suit against Renata, Dale, and GDR Holdings for estate fraud, conversion, and breach of fiduciary duty, supported by Dr. Holloway's forensic accounting report. Third, a complaint to the state medical board and potentially a referral to the district attorney regarding the physician's letter, which on its face appeared to constitute either fraud or the procurement of a fraudulent professional statement." She said, "The sequencing matters, because the competency petition is their offensive move. If we respond to it correctly, we don't just defend you. We use the response to establish, on the public record, exactly who you are and exactly what you've built, which then becomes the foundation for everything else." I said, "How long?" She said, "The motion to dismiss can be filed within 2 weeks. The civil suit within 60 days. The board complaint immediately, but I want to be honest with you, litigation is slow and it is uncomfortable. And there will be moments where it feels like the whole thing is designed to make you give up. The people who win are the ones who don't." I told her I had been practicing not giving up my entire life. I was very good at it. She almost smiled. Then she opened a new document and started typing. My family had made a particular kind of mistake, the kind that people make when they have been confident for so long that their confidence has curdled into carelessness. They had filed the competency petition without understanding what a competency hearing actually required. In most jurisdictions, a petition to declare someone legally incapacitated triggers a mandatory evaluation process. The court appoints an independent examiner, typically a licensed psychologist or psychiatrist, to conduct a formal assessment of the subject's cognitive and functional capacities. The subject has the right to present evidence, to call witnesses, to challenge the petition. The burden of proof lies with the petitioners. They had filed a petition supported by a fraudulent physician's letter, targeting a person with a documented processing disorder but no cognitive impairment, who held a granted utility patent, had active licensing agreements with 11 insurance carriers, managed a company with annual revenue in the high 6 figures, had purchased a home in cash, and had been maintaining meticulous financial and business records for the better part of a decade. Christine filed our response on a Monday morning. I want to describe what that response contained, because it was, and I mean this seriously, a masterpiece of legal architecture. The response opened with the motion to dismiss, citing the fraudulent physician letter as a procedurally defective basis for the petition, and formally requesting that the court investigate the letter's origins. It then provided, as exhibits, the following. Exhibit A, a current neuropsychological evaluation conducted by a board-certified neuropsychologist at a university medical center, finding no cognitive impairment, and noting that my processing disorder, while real, had no bearing on my capacity to manage my affairs, a distinction that the evaluating doctor took considerable care to explain in clinical language. Exhibit B, the patent grant documentation for United States Patent 10, 489-774, with a brief explanatory note from a patent attorney confirming the legal weight and commercial value of a granted utility patent. Exhibit C, certificates of incorporation and annual reports for my company, including the most recent fiscal year tax filings showing gross revenue. Exhibit D, a letter from my company's accountant summarizing the financial history of the business. Exhibit E, the deed to my home, showing cash purchase, no encumbrances. Exhibit F, personal tax returns for the previous 5 years. Exhibit G, letters from 3 professional colleagues, each of whom described working with me, their experience of my decision-making capacity, and the specific nature of our professional relationships. Exhibit H, an expert declaration from Dr. Patricia Holloway, which did not yet detail the estate fraud but established her credentials and noted that she had been retained to conduct a forensic review of estate-related financial transactions. That last one was deliberate. Christine wanted it in the public record that a forensic accountant was already involved before the civil suit was filed. Before we had revealed the full scope of what we knew, she wanted to see how my family responded to the knowledge that someone had been looking. The answer came faster than either of us expected. Renata called me 4 days after the response was filed. I had not spoken to my sister in 3 months, not since a brief and strained conversation at our cousin's birthday gathering, in which Renata had suggested, with the particular casualness of someone trying not to seem like they're testing you, that I really ought to think about getting some help managing my finances, and that she and Dale would be happy to sit down with me if I needed guidance. I had said, I appreciate the offer, and then I had gone home and called Marcus. Now Renata was calling, and her voice had a quality I had rarely heard in it. Not the crisp confidence she usually wore like body armor, something tighter, something that was trying to sound normal and wasn't quite managing it. She said she'd heard from Mom that I had filed some kind of response to the court, and she wanted to understand what was going on. I said, Renata, you filed a legal petition to have me declared incompetent. I responded to it. That's how legal processes work. She said she was just worried about me. She said Dale was worried. She said Mom was very upset. I said, I'm sure she is. Renata said she thought maybe we could talk, figure things out as a family, before things went any further. I said, I'd encourage you to speak with your attorney. She was quiet. Then she said, What do you mean? I said, I mean you should make sure you have good legal representation, because the estate fraud matter is going to be filed as a separate civil action within the next few weeks, and you'll want someone to advise you. The silence on the other end of the phone was the silence of someone whose careful plan has just developed a very significant crack. She said, estate fraud? That's a serious accusation. I said, yes, it is. That's why I hired a forensic accountant. Then I said I needed to go, and I ended the call. I sat in my home office for a while after that. Outside, it was a gray afternoon, the kind of flat winter light that makes everything look like it's waiting. I thought about my father, about his careful handwriting on documents, about the way he used to explain engineering problems at the dinner table, not to anyone in particular, just because he found the thinking beautiful, about whether he had known in some part of him what might happen after he was gone, about whether there was anything he could have done differently, or whether the outcome was always waiting there, patient as water, finding its level eventually. I didn't let myself stay in that feeling for long. I had work to do. The competency petition was dismissed 6 weeks after Christine filed our response. The judge's written order was 5 pages. The core of it was precise. The supporting medical documentation was found to be procedurally deficient, and the court had referred the matter to the state medical board for review. The petitioners had failed to meet the evidentiary threshold required to warrant a formal incapacity evaluation. The petition was dismissed with prejudice, meaning it could not be refiled without substantially new evidence. Dismissed with prejudice. I have those 3 words saved in a folder on my desktop. I look at them sometimes when I need to be reminded that the system, slow and imperfect as it is, occasionally does exactly what it's supposed to do. 2 days after the dismissal order was issued, Christine filed the civil suit. The complaint was 43 pages. Dr. Holloway's expert report was attached as an exhibit. The complaint named Renata, Dale, GDR Holdings LLC, and my mother as defendants, alleging estate fraud, conversion of estate assets, civil conspiracy, and unjust enrichment. The total damages sought, including the redirected estate assets plus interest, legal fees, and consequential damages, was $480,000. I want to be clear about something. I did not need that money. My business was profitable. My home was paid for. My life was, financially, stable in a way that had nothing to do with my father's estate. But that money had been my father's. It had been meant to pass to me and my sister equally. And they had taken it while filing papers to have me declared unable to manage my own life. I wanted accountability, not just payment. Accountability. The civil case moved through the legal system with the particular grinding slowness of civil litigation, which is to say that months passed in which things happened that were significant but invisible, depositions scheduled and rescheduled, document productions requested and negotiated, motions filed and answered. I stayed out of it as much as Christine would let me. I ran my business. I answered her calls. I reviewed documents she needed my eyes on. I waited. What was not slow was the medical board investigation. The physician who had signed the letter supporting my family's competency petition, whose name was Dr. Harold Fenster, was the subject of a formal investigation that the board had opened within 30 days of Christine's complaint. Marcus had continued to dig into Dr. Fenster's background, and what he had found was that Fenster had a history, not criminal, not disqualifying, but a pattern. 2 previous instances in the last decade in which he had provided professional letters or certifications in situations where his direct clinical contact with the subject was questionable. Neither had risen to the level of a formal complaint before. This one did. The board investigation took 8 months. At the end of it, Dr. Fenster's license was placed on probation for 2 years. The board's finding was that he had issued a professional certification without sufficient clinical basis, which was a formal way of saying he had signed something he shouldn't have signed about someone he had never examined. The board's order didn't name my family explicitly. It didn't have to. The causal chain was clear to anyone who cared to look. What happened to my mother during all of this is the part I have found hardest to write, not because it excuses her, but because it is genuinely complicated, and I am not interested in pretending otherwise. My mother was 72 years old. She had spent 50 years in a marriage in which my father, despite his genuine love for her, had made essentially all financial decisions. When he died, she was left with assets she didn't fully understand, an estate process she found bewildering, and 2 children, one of whom showed up immediately with a plan. That child was Renata. Renata had always been the decisive one, the confident one, the one who took charge. My mother trusted her the way parents often trust their most competent-seeming child, which is to say deeply and without much examination. I'm not saying my mother was innocent. Her signature was on the competency petition. Her account had been used to route the estate funds. She had signed documents she should have scrutinized. Under the law, her knowing participation made her liable regardless of who had originated the scheme. But I also know my mother. I know that she signed things because Renata brought them to her and explained them in a way that made them sound routine. I know that she put her name on the competency petition because Renata told her it was for my own protection. I know that she genuinely believed in some part of herself that I needed managing, because that was the story she had been told about me since I was 9 years old. And she had told it to herself so many times that it had become something she experienced as love. That doesn't make it right, but it is true. 3 months into the civil litigation, my mother called me. She was crying in the way that elderly people cry, with a kind of helplessness in it, a physical diminishment. She said she didn't understand what had happened. She said she didn't know Dale had done those things. She said Renata had told her it was all just paperwork, just reorganizing, just protecting the family. I listened to her cry for a long time. Then I said, "Mom, I need you to talk to Christine Weller. I need you to tell her everything you remember about who brought you documents, what you were told they meant and when. Can you do that?" She said yes. My mother became, in the legal terminology, a cooperating witness. It was the most painful thing I have ever navigated. It was also the right thing, and it clarified, in ways that were important to the case and to the accounting of what had happened, exactly where the center of gravity of this scheme had been. It was not my mother. It had never been my mother. The deposition of Dale Raymond took place on a Thursday in October, in a conference room at Christine's office, with a court reporter and a video camera, and Dale's attorney, a man named Greg, something who had the specific uncomfortable quality of a lawyer who suspects his client has not been entirely honest with him. I was not present in the deposition room. Christine had advised me not to be there, and she was right, because my presence would have introduced an emotional variable into what was a purely clinical exercise. Instead, I was in the waiting area with my laptop working. Christine told me afterward how it went. Dale had initially been confident, explained the LLC, claimed the commercial property sale and fund transfers had been authorized by my mother as the estate executor, claimed that my mother had chosen to give assets to Renata as a gift, claimed the whole thing was a family decision that hadn't involved me because I had shown no interest in estate matters. Christine had then introduced Dr. Holloway's forensic report with its transaction-by-transaction documentation. She had introduced the estate attorney's records, which showed the will's equal distribution requirements. She had introduced my mother's cooperating witness statement, which stated clearly that she had signed documents she did not understand and had not been advised to review independently. She had introduced the registration date of GDR Holdings, 11 months before my father's death. Dale's confidence, Christine told me, had developed several visible cracks by midday. By the end of the afternoon deposition session, he had taken the fifth, meaning he had invoked his Fifth Amendment right against self-incrimination in response to 14 questions. When someone takes the fifth in a civil deposition, it doesn't mean they're criminally charged, but it means a jury, if it comes to a jury, can draw an adverse inference from their silence. It means the story they were trying to tell has become too dangerous to continue. His attorney's discomfort, Christine noted, was not subtle. The case settled 7 months after filing. I want to be precise about this. I did not want to settle. Christine sat me down and explained, with her usual absence of drama, the calculus. Settling was faster, it was certain. A jury verdict is never certain, even in a strong case, because juries are human, and civil trials are expensive, and the emotional toll of a public trial on everyone involved, including me, was real. The settlement offer, which had come after Dale's deposition, was significant. The defendants agreed to pay $422,000. This reflected the estate assets redirected, plus interest, plus a portion of legal fees. GDR Holdings was dissolved. The 2 investment properties which had appreciated since purchase were liquidated, and the proceeds included in the settlement. There was no admission of liability in the settlement language. There never is. But there is a document filed with the court that records the settlement amount. There is the medical board order, which is public. There is the court's dismissal of the competency petition with prejudice and its referral of the physician letter for investigation. These things exist in the public record. They do not disappear because we signed a settlement agreement. Renata and Dale know that. I know it too. I want to tell you about the moment I think of when I think about how all of this ended. Not the settlement, not Christine's call telling me the check had cleared, not any of the legal milestones. There's a moment from about a month before the settlement, when things were still in motion and uncertain, and the weight of all of it was pressing on me in the way that sustained legal conflict presses on even the most resolved person. When I drove to a state park about 40 minutes from my house and walked a trail I used to walk with my father when I was young. It was late afternoon. The light was the particular amber of autumn, the kind that makes everything look briefly luminous and a little unreal. I walked for about 2 hours. I didn't think about the case. I thought about my father, about the way he used to name the trees when we walked, not to test me, just because he found naming things satisfying, like it completed some circuit in his brain to identify a thing correctly. Red oak, tulip poplar, shagbark hickory, ironwood. He would have hated what had happened. He was a private man, deeply private, the kind of person for whom a legal dispute would have been a personal wound regardless of who was right. He would have wanted it settled quietly, would have been mortified by the court filings, by the forensic accountant, by the deposition. And he also would have, I believe, wanted me to fight it. Because underneath the privacy was the engineer's commitment to accuracy. Things should be as they actually are, not as it is convenient to pretend they are. My father believed in the correct answer. He believed in knowing what something actually was, and not pretending it was something else for the sake of comfort. I had inherited that from him. In my own way, in my own life, in the software I had built and the patents I had filed, and the meticulous records I kept, I had inherited that. It was, in the end, what saved me. I am not going to tell you that my family relationships were repaired because they weren't. I am not going to tell you that there was a reconciliation because there wasn't one. My mother and I speak. It is different now. There is a careful quality to it, like we're both aware of the weight of the ground we're standing on. I have not forgiven her in the sense of pretending it didn't happen, or that her signature on that petition was without consequence. But I also have not cut her off because she is my mother, and she is 72 years old, and the line between her culpability and her manipulation is real. Even if it doesn't erase her choices, it is the most complicated relationship of my life. I am learning to hold it as complicated rather than trying to resolve it into something simpler. That is hard work. I do it because the alternative, which is either pretending everything is fine or cutting off all contact entirely, both feel like lies. Renata and I do not speak. I do not expect that to change. What she did, the deliberate planning of it, the specific cruelty of using my disability as the lever, the choice to frame my competence as the problem rather than her own dishonesty, those things are not things I am interested in finding a path back from. Some relationships end not with a dramatic rupture, but with a slow, documented accounting, and then a door closing quietly. The door is closed. Dale faces potential additional exposure because the district attorney's office, which had received a referral from Christine at the time of the civil filing, has an open inquiry that has not yet concluded. I don't know how that will resolve. It is not in my hands. What I want to say to you before I close this is something about what it means to be underestimated. There is a way that being underestimated feels like being erased, like the version of you that exists in someone else's mind has been substituted for the actual you. And no matter what you say or do, you're somehow arguing against a settled verdict. I know that feeling. I lived inside it for decades in my family. I watched people talk over me, finish my sentences wrong, make decisions on my behalf without asking, and accept as self-evident a version of me that had nothing to do with who I actually was. Here is what I know now. The people who underestimate you are not seeing you. They are seeing a story they have told themselves, and they have made themselves comfortable inside that story, and they are often building things on top of that story. Financial things, legal things, plans that require you to remain the person they've decided you are. The most dangerous thing you can do to someone who has built a plan around your smallness is to simply be large. Not aggressively, not performatively, just large, real, documented, accurate. I did not set out to destroy my sister. I set out to exist accurately and in full in my own life. The destruction of her plan was a consequence of my existence, not the goal of it. That distinction matters to me. It shapes how I carry all of it. The patent is still generating revenue. The business is growing. I have added a 4th full-time employee and am in conversations with 2 additional carriers about expanded licensing arrangements. The house is still paid for. The home office still has the yellow legal pad on the desk, though I have started a new one. Marcus sent me a bottle of good whiskey when the settlement cleared. I am not much of a drinker, but I poured a small amount and raised the glass to nobody in particular and thought, this is what it looks like when the record is accurate. This is what it looks like when the documents tell the truth. Christine sent a brief email, as is her style. Congratulations, it was a pleasure working with you. Call me if you need me. I will. I hope I don't have to, but I will. Dr. Holloway's forensic report is archived in my files. I don't look at it often, but it is there. The way a foundation is there, invisible and load-bearing and real. I want to end with something my father said to me once. When I was about 15 and I had come home from school in that specific state of adolescent misery that comes from being told, yet again, in some classroom or hallway, that you're less than the other kids. He was at the kitchen table with a set of engineering plans rolled out in front of him. And I came in and sat down without saying anything. And he looked at me for a moment and then went back to his plans. After a while, he said, without looking up, there are 2 ways to answer a person who tells you you're wrong. You can argue with them, or you can be so undeniably, precisely, irrefutably correct that the argument becomes unnecessary. He said, the first one is more satisfying in the moment. The second one is more satisfying in general. Then he went back to his plans. I was 15. I didn't fully understand what he meant. I filed it away in the part of my brain where I put things that feel important before I can explain why. I understand it now. I was declared incompetent by the people who had the most to gain from my incompetence. I responded not with argument, but with documentation, with a granted patent, with a forensic accountant, with 5 years of tax returns, with a neuropsychological evaluation, with a licensed private investigator who had 19 years of experience and a very good forensic accounting contact, with an attorney who builds cases like bridges. The argument became unnecessary. It took longer than an argument would have. It was less satisfying in the moment. In the final accounting, in the public record, In the documented and irrefutable truth of who I am and what I built and what was done to me and how it ended, it was more satisfying than anything else I can imagine. My father was right. He usually was. The files are in order. They always were.